We are so excited that you can join us and learn about supported decision making. So I want to go over some housekeeping notes. Today's program is being recorded. Closed captioning as well as ASL is provided. You may need to enable closed captioning. You can hit the closed captioning and then hit view subtitles if you need to. And then you can also enable the size of the closed captioning in the subtitle settings. There'll be an opportunity for questions at the end of the presentation. If you have specific legal questions about a consumer, family, or friend, please contact Disability Rights Pennsylvania. They'll love to start talking to you and get an intake going. The slides and the recording will be sent to you at a later date then. We're going to give it a minute and then we're going to get started. Okay. So I just want to briefly talk to you about why we're here and who we are. So the Lehigh Valley Center of Independent Living and Jewish Family Services of the Lehigh Valley has been partnering for over a year now, not only researching supported decision-making models from various states, but also hosting supported decision-making informational sessions. We're working on building a pilot program, and we are all about advocating for individuals with disabilities to really become more empowered. We connected with Disability Rights Pennsylvania a few months ago regarding supported decision-making in PA. And the moment we met Elysia Mancini Duerr, she's a guardianship attorney, we knew that we really needed her in our educational sessions, because not only is she a fantastic guardianship attorney, but she's a force. And she's very knowledgeable and is a fierce advocate for individual disabilities. So she's going to run the second half of the programming today. And I wanted to quickly introduce myself. I'm Amanda Thomas. I have my Ph.D. in special education, and I'm spearheading the SDM pilot program in the Lehigh Valley.
Come here, please.
And just for a reminder about the closed captioning, you can enable them and change the size, and we'll hold our questions to the end, and the transcripts, everything will be sent to you later. So why are we here today? We're here to give you information about supported decision-making. So when your consumers and your consumers' parents are navigating or exploring substitute decision-making options, you're informed about all the options and how to begin incorporating SDM. We really want to avoid guardianship as being the default solution, and we always want to presume competence. So being able to make a choice about your life is crucial for independence and happiness of all people, including those people with disabilities. Decision-making is a skill, and everyone needs practice. Just like all of us, we continue to grow and gain through experience throughout our lives. So regularly involving young people with disabilities in decision-making results in adults who are now able to make informed decisions and direct their lives. So here is a graphic that I created about all the different options that are available. Under Pennsylvania, there are several alternatives to guardianship that can be viable decision-making options that can serve many issues, that can solve many issues for individuals and their families that they may face throughout the lifetime. And adults with disabilities don't necessarily need to have a guardian of their person or the estate to help them make medical, financial, or other decisions. Most people with disabilities can live their whole lives without guardianship. They just may have other options in place, and that's what we're here to show you. And Elysia will go over each of these options later in the presentation. So I have a polling question for you. It's going to pop up and it's anonymous, and I'm just collecting data as we go, just getting your viewpoint. So what I want to see is, are you aware of these spectrum of alternatives? And I would like to ask, if you are not speaking, if you could please mute yourself. Thank you. All right, so it looks like there's a mix. And that's great, that's why we're here. Okay. All right, so Elysia is going to briefly discuss about guardianship, but I just had one question for you, another polling question before we begin. Thank you for voting. I thought it's important that we talk about guardianship before we get into supported decision-making, because we found some misconceptions about guardianship. And Elysia, did you want to take it over?
Sure, I can. This presentation, just to start, we're not going to tell you how to petition for guardianship. There's plenty of lawyers who will take your money and do that. But just to give people an overview of what's important to understand is that you have to be incapacitated to have a guardian. That incapacity has to be proved in court. The incapacity has to be backed up by an expert who can be a psychologist or a medical doctor. And there's two types of guardianship: guardianship over the person and guardianship over the estate. And that the person who is being declared incapacitated has rights, and you really shouldn't be trying to get around those rights. Sometimes petitioners for guardianship are surprised that the person has a right to a lawyer or a right to be present in court. But those are really important rights, because when you are petitioning for guardianship, you're essentially petitioning to take away that person's rights to make decisions for themselves. So they should have the right to know what's going on and be present and have a lawyer. I guess next slide. Okay, so the other misconception I like to clear up is guardianships don't have absolute authority to do everything. And it's important for petitioners for guardianship to know that, right? What they can't do is listed on this slide, right? They can't ever, under any circumstances, put someone into a psychiatric facility, for example. So that's important for petitioners to know, because sometimes people are petitioning for guardian because of his psychiatric disability, and being a guardian doesn't really help with that. They can't refuse life-preserving treatment. There's other things they can't do that are listed there. You can't, some things you can do, but you have to go to the court to seek permission, like prevent the person from getting married. There needs to be a court hearing on why the guardian thinks they should be married. And then there's other rights that are considered fundamental rights that are often in conflict, that sometimes guardians think they have the right to prevent the incap from having, like the right to associate with friends or the right to vote. And there's assumption that people who are incapacitated still have these rights unless the court order for guardianship specifies that they lost those rights. So it's not like an ultimate power that a lot of guardians think it is, although it is the most restrictive form of substitute decision-making. It's not ultimate decision-making.
Thank you. So we have worked, we collaborated with Support Decision Making New York at one point, and I want to show just a brief 3-minute video about supported decision making.
Supported decision-making is the process by which people with intellectual and developmental disabilities make their own decisions with the support of trusted people in their lives called supporters. It also allows them to retain all of their legal and civil rights. The Supported Decision-Making New York pilot project has shown that supported decision-making works in a variety of different ways for people of all ages, races, and ethnicities, regardless of their disabilities. Here are just a few. Ganesh is a decision maker who lives with his parents in Queens. He has studied business and worked in data entry and bookkeeping. When possible, he volunteers at Queens Community House. Ganesh plays classical piano and cooks all types of Indian food. His mother, Meena, who is from Tamil Nadu in southern India, joined him to talk about supported decision making.
It will help me to get all the inputs from others that I can make on my own. Like decisions about what school is gonna help me with my job search, and then I can make the decisions on my own.
When Ganesh was little, when he was 18, we just took the guardianship because we had no idea how independent and able he would be when he reached that age. And then I heard about the supported decision making, and it's a very good fit for him because he's quite capable of making a lot of decisions. But it is good for him to get input from some other people.
Ella is a 24-year-old decision maker who lives in Troy, New York. She works at the Diamond Hill Nursing and Rehabilitation Center. She also volunteers with people with disabilities using her 5 rehabilitation horses.
It's important to me to be able to identify the people that I have for supported decision making and what part they take in the process. It's also important to me that I make my own decisions and not have somebody else making for me.
Gerald is an LGBTQ activist who lives with a roommate in a residence in Harlem run by ADAPT Community Network. He first heard about supported decision-making at an information session given by SDMNY at a Self-Advocacy Association of New York regional conference.
What attracted you to supported decision-making? What made you interested in doing it?
He said it's about him making his own decisions. That's what you said?
And why do you think having a supported decision-making agreement is important for people who might need support communicating their decisions to others?
Because they hear you? Hear him in his words.
Harvey is
Okay. That is she has great videos. It's going to be a great resource, SDM and Y on supported decision making. Okay, I'm going to reshare. If you have any questions, you can chat it out. I don't know if we'll be able to get to them, but we'll save the questions to the end. And if you just want to write it out, you can earlier. Okay, so what is supported decision making? Supported decision making can sound like a new foreign idea, but maybe you're already implementing supported decision making to a certain degree using person-centered planning. So with supported decision making, the decision maker or the individual with disabilities chooses the people that they trust to help them gather and understand information, compare options, and communicate their decision to others. It's really how most people make decisions. So the decision maker identifies what decisions they really need support with, like maybe finding the best internet provider, or filing taxes, or things with housing, or going to school, or relationships that they might need, just some help navigating. The decision maker also decides what kind of help would be useful in making these decisions. So they might need help with gathering or understanding the information. So if they have a medical procedure, what are the pros and the cons? Or understanding the information that was given to them, or perhaps communicating decisions. The possibilities are endless. But ultimately, the individual with disabilities is the decision maker. This supported decision making does not restrict the person. The decision maker is always in control. And the supporter doesn't have any rights. The supporter has no authority to make decisions for the decision maker. It's always up to that individual, the decision maker. So what is supported decision making? It's not a general plan. It's not done in an annual meeting. It's individualized. It's flexible. It's really based on the decision maker's ability, and it can really change over time. As the individual continues to gain life experience, they might need less support, or they might need an increase in support. There could be a scaffolding of support, either way. And it's really working to identify where the help is needed and how it can be provided. And you may have heard it in like circles of support, formal microboards. These are all other terms that have been used in the past. So what's the role of the supporter? So this is after the individual, the decision maker, reaches out and says, hey, I need some help. Will you be my supporter to help me navigate this decision? So the supporter will help this decision maker access, collect, obtain information, help them understand the information, goes over maybe the consequences of what might happen either way, but without making the decision, and assist in communicating that decision to others. So what are the benefits of using SDM? Supported decision-making is a fundamental part of self-determination. And people with greater self-determination the research has shown people are healthier, more independent, well-adjusted, really better able to recognize, resist abuse, and really live a higher quality life. But the big question here is, well, what if I don't agree with that decision maker's decision? But so decision-making is a skill, and everyone needs practice. And just like all of us, we need to continue to grow and gain experience through our lives. So making mistakes prepares us for future decision-making. There is dignity in being able to both succeed and fail and learn from our failures. So learning is a lifelong process and really doesn't end at 18. People with disabilities can learn new skills and increase their independence throughout their lives. So it's important that we give them that and they get that experience. Well, what about exploitation? You might have concerns about that. So anyone, it's still the same. Anyone that suspects that a supporter is abusing, neglecting, or financially exploiting a person with disability can report their concerns to elder or adult risk agencies or the appropriate law enforcement. So what about SDM in Pennsylvania? Does it need to be legally recognized? Like in other states, it's built into a formal bill, but it's already there, and Elysia will explain more. It's in case law in this Peary case, and it's showing that if that individual has a circle of support or has supporters to help them make decisions, that they don't need guardianship. And what about an SDM formal agreement? So other states might have a contract or an agreement that you sign that's law abiding. But after doing our research, talking with other states, looking at different things, we feel it isn't 100% necessary. And I didn't know, Elysia, if you wanted to touch on that from your experience from being at the National Guardianship Council.
I can if you like, or I could wait. I mean, but the bottom line is everyone here engages in supported decision-making, right? That all it is a fancy term for saying we ask for help from other people when making decisions. So to put a label on it when it comes to people with disabilities actually can be kind of exclusionary. And right now there's 12 states that have it codified, meaning it's in the statute. We do have case law, and I'll talk more about that later. So it is part of our law, not through a statute, but through a case that went up to the Supreme Court of Pennsylvania. And they just acknowledged that people with disabilities can get help from others to make their decisions. And this is an alternative to guardianship. So it's actually pretty simple, a concept, but it gets overcomplicated, I think. And I'll talk more about it in my slides.
Okay, thank you. So what our goal for Lehigh Valley is Jewish Family Service and Lehigh Valley Center of Independent Living. We're partnering together, as I said earlier. We're making supported decision-making Lehigh Valley. And what our plan is to do a pilot program that does a program specifically an intensive program that walks through training the decision makers on how to make decisions, how to problem solve, how to communicate with their supporters and anyone else that they need help with. And then just a brief training for those supporters. And if they problem solving, if they need any help. And then a website that's in progress now for materials, resources, and trainings, as well as these informational sessions to really get outreach and kind of start putting everybody, reframing it. And so everyone's starting to use supported decision-making more and more. All right, so I'm going to reshare my screen so that you can see everything. Hold on. Okay. Okay, so maybe a burning question that you have is, how do I start this? How do I start SDM? Well, I wanted to give you, I think it's really important to give resources, to give information. That's how I'm hoping that it'll be helpful for you too as well. So there's practical practitioner-friendly articles in Teaching Exceptional Children. I have the 2 articles right here. One is specifically for special educators to really take some steps for self-advocacy, and another for step-by-step instruction on how to run and an individual with disabilities, a student running their own IEP meeting and building that empowerment, because it is so important and it's critical and it's maybe not happening enough in schools. Another resource is looking at like the first steps in teaching SDM. So presenting the consumer with choices and honoring their decision. And it could be really starting with simple decisions and working their way up. One of the programs that I run at Lehigh Valley Center of Independent Living is adaptations, and all the programming is designed by my consumers. They tell me the different events that they want to attend, the different independent workshops that they want run and they want to learn about. And it's just providing them with taking the lead and empowering them more and more. And also begin encouraging the consumer to make meaningful participation in their IEP meetings as soon as possible, which is critical. Teaching the consumer how to problem solve using a simple model, and then making sure you practice and model the process as well. Talk out loud as you're problem solving with them. Encourage interdependence and the greatest level of independence. Too often we view decision-making as an absolute, competency for decision-making as an absolute. Can you use a combination of supports with SDM? Absolutely. It's not just SDM and that's it. And that's why I showed you that graphic in the beginning, that there's a lot of different things that you can pull in. And this I got from support.mydecision.org. And there's just a lot of different examples on, if you're looking at the need, how this can be accomplished. And there's a variety of different things that you can do. And some more resources. This one I enjoy. This is getting students to self-advocate and to step-by-step through ASHA. And it just helps, it goes through everything that you might need. And it has some really great steps, has some really great graphics that I think that would be really beneficial for you. As well as this, we have talked to Wisconsin about their SDM program, and they are a great resource. So we've been meeting with them a lot, and they have a workshop or conference that I thought would be great. You have to register by tomorrow, but if you could share it with your consumers, there's a lot of cool things that they're doing, and I think you should check it out. And I have some more. This decision-making webinar is specifically for adults with disabilities, and it is a great option. And this one, Support Decision-Making Guide. This is the National Center for Support Decision-Making. This has a ton of resources. There's a lot of education. There's a research library and also a resource library. It breaks it down by state. There's a lot of webinars and presentations. So if you could look at as well, if you wanted some more information on it. And then of course, Disability Rights Pennsylvania, they have some different handouts about the alternatives to guardianship. So it's under resources. And then you can just pull up different things, different handouts. So it's pretty cool.
It's under the estate planning section, estate planning substitute decision.
Yes.
Yeah.
Yeah, and then any of these are good resources too. And because I have some research in my background, I reached out to Kansas. They're doing a lot of supported decision making, and that's where I'm getting a lot of the different surveys that we're going to be using. They have a great program, a great resource center that you can look at as well. Advice for families, how to do it, how to choose your supporter. And then the last one is a resource library that has some self-assessments, some evaluations on competency. I know some people have asked when they were registering, so I thought this would be a good information. Okay. Just general information. There's a video library, even tools, different things. So I just wanted to give you more than enough resources. And finally, we are, Elysia and I, and our team, we are going to be putting on a presentation specifically for adults with disabilities understanding their rights. And this is specifically geared to them. It's going to be a discussion, a question and answer, where they're going to learn different options and learn about the alternatives to guardianship, and then also learn about, self-advocacy and how to use supported decision-making throughout their life. And it's going to be next month. I will send you more information about it. I think it will be in the chat, and you can just send that registration link to all of your consumers if you're interested. Okay, so Elysia is going to take over, and then I'll be back for some questions.
You be able to move the slides, or do I?
I can. Yeah.
Okay, so we could go to the next one. I'm Elysia. I work for Disability Rights Pennsylvania. I'm a staff attorney, and I've been doing this kind of work for over a decade on my own, and then for the past 2 years for DRP. This is my email address and my phone number. If you have a specific question about a specific consumer, I would suggest you don't ask it in this forum, but rather you reach out to me, and I can take you in as an intake and give you advice and information. All right, so next slide. The bottom line for this presentation is I saw the attendees list, and there's a lot of people attending who are in what we refer to as the pipeline to guardianship, meaning they accidentally refer people to guardianship. And if we can stop that pipeline or slow it down, that's my goal. Because the bottom line is, even if people are completely incapacitated, there's a lot of alternatives to guardianship in Pennsylvania. And telling someone that they need to seek guardianship for their loved one is usually not correct. So please stop doing that if you've been doing it. And maybe a better suggestion is to tell them to call Disability Rights Pennsylvania or talk to a disability rights lawyer to see if they need a guardianship. But telling people from the start that they need to file for guardianship when that's usually wrong information is causing a lot of unnecessary guardianships to come through the pipeline to the court. So I'm going to go over what those alternatives are to guardianship. Next slide. So Amanda talked, but from a philosophical standpoint, the reason preventing guardianship is so important is because people do have the freedom to make decisions, and that's a really important freedom. Their autonomy is important. And in a legal sense, a guardian is a substitute decision maker. That means they are making decisions for the person, not with the person, but for the person. So preventing that limitation of people's decision making is important. There are other forms of substitute decision making that are less restrictive than guardianship. Under the law, guardianship is considered the least restrictive form of substitute decision making. And sometimes people do need some kind of form of substitute decision making, but there's other choices other than guardianship. And sometimes people can work with substitute decision making, which Amanda talked about, and supported decision making. I'm sorry, Amanda talked about supported decision making. Sometimes that needs to be worked with in combination with substitute decision making. And I'll talk about how that's possible. But guardianship is like the ultimate form of substitute decision making. It's the most extreme. I think I mentioned that people who have a guardian have been deemed incapacitated by the court. And what does that mean in a legal term? Capacity means someone does have capacity. It means they can understand a situation, understand the risks and benefits, use the information they're given to make a logical decision, and communicate that decision. Doesn't have to be verbal communication, but they need to be able to communicate. And if someone can do those things, they do have capacity. If they can't, then they're incapacitated. Next slide. So an important takeaway of this is guardianship in the statute itself, in the law. It says that it should be a last resort because it's the most restrictive alternative when it comes to substitute decision making. And what is required for guardianship is here on this slide, but it's important to notice that it should be a last resort, and it even says that in the law. So if someone is 18 and their parents are petitioning for guardianship, I take the position that that petition is correct, because there's no way those parents know if a less restrictive form of substitute decision-making will work. And the law says less restrictive alternatives must be explored before seeking guardianship. So if these less restrictive alternatives have never even been explored because the person just turned 18, you don't know that they will work or not. And the law says you have to look at less restrictive alternatives first. Next slide. These are just the rules in the law. I'm just citing it, where it says less restrictive alternatives must be sought first before someone petitions for guardianship. This is just an added pointer of why guardianship is not the best thing. So like, why is it the most restrictive? Well, it's restrictive in lots of ways, not just for the decision maker, not just for the incapacitated person, but it's restrictive for the guardian. Very expensive. They have to pay a lawyer to file for guardianship. You often have to pay a lawyer to file annual reports, which are required. If you don't file those annual reports, you can get in a lot of trouble with the court. It's very restrictive. Again, it takes away the incapacitated person's decision-making, and it's very intrusive. The reports for the guardian require a great deal of detail about everything the incapacitated person has done, all the money you've spent for them. The court is really a part of that family's life once they become guardians of their loved one, and it eliminates almost all privacy. These are the alternatives. I'm going to go over each one in turn. They're listed here for you, and I think you can get a copy of these slides if you want to see the list, but we will move on to go through the list. So the first thing, obviously supported decision-making. Amanda already talked about that. Again, it's very simple concept that's made overcomplicated, but it's just saying that people can have a network of support to help them make decisions. And I use supported decision-making, right? I'm married, my husband is part of my support team. I have friends, I talk to them about my decisions. That's all supported decision-making is. But for some reason, when it's a disabled person, it becomes something bigger, even though it shouldn't. So recognizing that everyone needs support, even persons with disabilities, that's what supported decision-making is. It's not too complicated. So we're going to go to the next slide, which is going to talk about the legal authority of this. And I mentioned this before in Amanda's part of the presentation. There was a Supreme Court case. It was called in R.E. Peary. And what that case was about was a woman who had an intellectual disability. She lived in a group home, and her brother filed for guardianship. And what the court ultimately concluded was that she did not need a guardian because she had support. She had a case managers, she had friends, she had social worker, professional and personal supports. They called it a circle of support. And they said with this circle of support, it was as if she was not even incapacitated. So basically what the court was saying is maybe alone, if she lived in a bubble, she would be incapacitated. But when you take into consideration a person's support network, and that support network can help them make decisions, now they're no longer incapacitated and they don't need it. It's just recognizing that. So because we have that case on the books in Pennsylvania, I feel like we don't really need a statute codifying supported decision-making. Maybe we'll get one someday, but for now we have this. And if people acknowledge it and acknowledge that persons with intellectual and cognitive disabilities can allow other people to help them, then I think we're okay. Oh, I just saw a pop-up that I don't have a slide for, but I'll address it at the end. How do you reverse a guardianship for someone who's incapacitated? Remind me at the end. Okay, so now supported decision-making does have limits. I don't think Amanda talked about those limits, right? But there are limits to it. It doesn't always work. Doesn't work if the person doesn't want help, right? If they absolutely refuse help. It doesn't work if they have a legally recognized substitute decision maker like a guardian, because remember, a guardian is not a supported decision maker. A guardian is a substitute decision maker. It doesn't work if the person with the disability cannot communicate in any way whatsoever. Now, it will work if the person can communicate with limitations, and it will work if there's someone who can understand how that person communicates. But if there's no way whatsoever for the person to communicate, then they obviously can't tell you what their decisions are, and then supported decision-making won't work. Some things where the authority figure will require something more than supported decision-making, and I'll talk about that, especially healthcare. And luckily in Pennsylvania, we do have a way to deal with that. But sometimes a doctor or a surgeon will just say, I refuse to do this surgery because I don't believe this person can give informed consent. And I think I'm liable and I refuse to do it. So what do you do when that happens? I'll talk about that later. Okay, so next slide. So this slide I added because Amanda asked me to, and she said it has come up where some people believe you need to become a guardian when your child turns 18 to make educational decisions. And that's not true. So in the state of Pennsylvania, the age of majority is 21. There's a federal law which says that states determine the age where a child reaches the age of majority. And in Pennsylvania, that's 21. So parents of children with disabilities can still make educational decisions like participate in the IEP meeting until the child turns 21. So no worries there. Next slide. I think someone has their mute off. If people could check. Anyway, so the next slide is about emergency guardianship. I list this as an alternative to guardianship because sometimes there will arise some kind of emergency where a doctor or it could be a lot of different scenarios. I can't think of all of them where you might need a substitute decision maker, but just for this instance, just for this time, you don't need it permanently. And it's important for people to understand that you could have a temporary guardianship. It's called an emergency guardianship just for the emergency. You don't have to apply for a full-on guardianship forever to take care of one instance that's an emergency instance. So there, for 72 hours, you can get a 20-day extension. And a lot of times emergency guardianships are filed if there's a medical procedure that needs authorization and there's no healthcare representative. I'll talk about healthcare representatives later. But I consider that to be an alternative to guardianship. Limited guardianships, I also consider to be an alternative to a plenary guardianship. Plenary guardianship is a full guardianship, either of the person or the estate, where the guardian has all of the decision-making rights. And a limited guardianship can be limited in time or scope to exactly what you need the guardian to do. And they're preferred in the law. I cite the law there because they help preserve people's rights. So if there's anything a person can do on their own, you want to let them keep that ability to do it independently. And if there's something they can't do independently, you can appoint a limited guardian just for that purpose. It's usually used for money. So I'll give an example. You could have a parent that's aging. Now he or she has dementia. He never filled out a power of attorney, and there's money he can't manage. How do you manage that? Well, you can become a limited guardian of the estate just to manage your parents' money, and that's it, and still give him his independence and autonomy to do other things. Anyway, that's one example. So that's an alternative to guardianship. Healthcare Advance Directive is another alternative to guardianship. I feel like I don't have to talk about this in too much depth. Most people know about healthcare advance directives. Some people think of it as a healthcare power of attorney. And that's when the person with a disability has enough capacity to understand and execute and appoint an agent. An agent is an agent is someone else who makes decisions for them, medical decisions. So the thing about, I'm sorry, I'm distracted by the chat pop-ups. The thing about healthcare advance directives is the person executing it has to have enough capacity to understand what they're signing because they're the one choosing their substitute decision maker. So again, it's less restrictive than a guardianship because they're choosing their substitute decision maker. They can be terminated at any time by the principal, that's the person signing, and it gives the person choice. Next slide. This is the same, I just discussed all this stuff, but it's basically if someone understands, they can sign a healthcare advance directive. So next slide, this next slide might be the most important slide. And the reason it's the most important slide is I find this is an alternative to guardianship that most people don't know about. It's underused and people need to know that it's here, right? So there is in state law an option called a healthcare representative. And healthcare representatives can be chosen by someone, but if the person is incompetent, which is another word for incapacitated, healthcare representatives kick automatically. And they're a really good alternative for healthcare decisions for someone who can't make their own healthcare decisions. You can go to the next slide. Let me see what the next slide says. Can you go to the next slide and then we might go back? Okay, so healthcare representatives by law kick in if someone's doctor says they're incompetent. And if someone's doctor is saying they're incompetent, the doctor is allowed to talk to the people listed on this slide to make the healthcare decisions for the incompetent person. So I remember I gave the example when I talked about when I gave the example of when I said when supported decision-making won't work. One of the times supported decision-making won't work is if the authority figure, the doctor, refuses to listen to the decision maker because the doctor believes the decision maker doesn't have capacity. So if a doctor believes person doesn't have capacity to give consent to a medical procedure, the doctor can choose to have someone on this list be their healthcare representative and make the medical decision for them. So this form of substitute decision-making works well with supported decision-making because you can have someone who can make all their own decisions for most things, but if it comes down to a serious medical procedure and the doctor needs someone to sign other than the decision maker, you know, their parents, if they're young, or their adult child, if they're old, can be their healthcare representative and can consent to their medical procedures for them. So this is a really good alternative to guardianship in Pennsylvania. It's really easy. It's not like guardianship. You don't need to go to court. You simply become a healthcare representative because the person in question is incompetent as per the doctor and because of your relationship to them, as long as you're one of these people. So I'm going to ask Amanda to go back a slide. There are limits on healthcare representatives. They're the same as the limits for guardians, right? They can't refuse life-preserving treatment. There's a presumption that if a guardian can't do something, they can't do it, like admit them to a psychiatric hospital. And in the law itself, there's a section that says the incompetent person has the right to countermand, meaning they have the right to say no. So if there's a medical procedure that they really need and they're refusing, that might be the time to seek a guardianship, but I wouldn't seek a guardianship before that, right? That's premature. See if this works first. See if you can be a healthcare representative for your incompetent loved one. And I'm using the word incompetent because that's what the statute uses. I don't like, but that's what the statute uses. So, and then, you know, if you have to, and that doesn't work, then you could seek an emergency guardianship, but try and see if being a healthcare representative will work first. So I saw a pop-up about a form. There is a form, you can move forward. I'll move forward again. So the law says that a form is only required if the health care provider demands it. And usually they do because they want to have a form for HIPAA compliance to make it clear that it's legal for them to be speaking to someone other than the patient. The law doesn't say how the declaration should look. This is a sample. We have a sample on our website at disabilityrights.org or disabilityrightspa.org. But the form is called a Healthcare Representative Declaration. It only needs to be signed by the healthcare representative. It doesn't have to be notarized. Again, you don't have to go to court. It's just a form. So it's a very good, easy alternative to guardianship. Okay, so now I'm going to switch and talk about another alternative to guardianship, which is just in the law. So there's a combination of laws. There's a law called Act 129. There's the Mental Health Intellectual Disability Act. There's a whole bunch of laws that when you take them together, it's been concluded that what it means is if someone lives at a facility for people with intellectual disabilities, like a group home or an institution, and they have no guardian or they have no substitute decision maker, the executive director of that facility can make healthcare decisions for them. And, you know, this is just to say, you don't have to file for guardianship. If a person is in a group home, the people who work at the group home are able to help them make these medical decisions. And I just did a case about this in court, saying this person really didn't need a guardian because she lived in a facility for people with intellectual disabilities, and the judge agreed. Next slide. Oh, I'm sorry. So we talked about healthcare advance for healthcare. There's another kind of advance directive called a mental health advance directive, and it's specifically for people with a mental illness. And if you recall at the beginning, I said people who had guardians, their guardians cannot place them in a psychiatric facility. So a guardianship is really the worst kind of substitute decision maker for people with a mental illness. They can't help at all. But a health power of attorney can put their principal, that's the person who signed the form, in a psychiatric facility if they were given that power. So a mental health advance directive is an advance directive for people with mental illness. It directs exactly what kind of care they would want if they had some kind of episode, some kind of mental health episode, and who would make those decisions for them. The drawback to these is they have to be refilled out every 2 years, but really good forms of substitute decision making for people with mental illness. Next slide. There's 2 parts to it. There's a power of attorney part where you designate someone to be a substitute decision maker if you were to have a mental health episode. And there's a declaration where the patient signs and articulates what they would want for treatment, what kind of medicine, what hospitals they'd want to go to, that kind of thing. So it's a good guide for people with mental illness in case they were to be hospitalized. It helps the doctors out a lot. Okay, so now we're going to switch gears and we're going to talk about money. And because everything I've already talked about is alternatives to the guardian of the person, but these are alternatives to guardian of the estate that I'm going to talk about now. So the first most basic alternative to a guardian of the estate is a representative payee. And if somebody has Social Security income, if they don't have any other income, they really don't need a guardian of the estate. It's totally unnecessary. And the reason it's unnecessary is because if they have a representative payee, that representative payee already gets all their income, is reporting about all their income to Social Security, is managing their income for them. So they don't need anything else. I feel like that's a real simple, should be real obvious, but it's not. And sometimes I see petitions in court for people who don't have any money other than Social Security. And I'm always going to make the argument in court that they don't need a guardian of the estate if they have only Social Security income. All they need is a representative payee. Next slide. Power of attorney is a lot like the healthcare advance directive, except it's for money. A person has to have the capacity to understand it, but they can sign and appoint someone else to make their financial decisions for them. I think this is a really good document. All banks understand it. You might want to make sure with your specific bank that they don't have their own power of attorney form, because some banks have their own form. But if a person has the capacity to understand that they're signing a document which allows someone else to help them manage their money, then legally speaking, they can execute a financial power of attorney. And that financial power of attorney can help them a lot. And if the person changes their mind, they can change their mind and appoint a new financial power of attorney. So again, it gives them the control as opposed to a guardianship choice. And well, first of all, with a guardianship, you don't have capacity and you have to have capacity to execute this, but it's like night and day in terms of choice and capacity. Next slide. Trusts are listed here as an alternative to guardianship because if someone has a trust and they're the beneficiary of the trust, the trustee doesn't have to be a guardian. And in fact, if you are a guardian and someone has a trust, that trust is completely outside of the guardianship estate. So if a person who's incapacitated has their funds in a trust, and it should be a trust so they can retain their benefits, again, they don't need a guardian because that trust is managed under other laws. And it's important, if you do get a trust for someone who has disabilities, that you make sure it's set up properly so they can maintain their Medicaid, Medicare benefits. Go to a lawyer that's a trust lawyer who can understand that. But again, you don't need a guardianship if you have a trust set up. Next slide. Okay, so this is kind of covers both finances and person. And Amanda talked about this, but sometimes people are concerned about exploitation and they file for guardianship because they think it's going to prevent something bad from happening that hasn't happened yet. You know, I see this especially with parents who are filing for guardianship for an 18-year-old. They imagine all kinds of horrible things are going to happen. So a guardianship is not the way to prevent something bad from happening. Even if you're a guardian, someone can try to exploit your loved one. And even if you're a guardian, someone can try to abuse your loved one. Guardianship is not going to prevent that. What's going to prevent that is you being actively involved in that person's life, helping them with supported decision-making, as Amanda explained. Guardianship doesn't put them in a protective bubble. And if there is some kind of abuse or neglect, this is the phone number to call. It's the same phone number for adult protective services and older adult protective services. And that's where abuse and neglect or exploitation should be reported. I think I have another slide about it, if Amanda can move forward. These are the things listed on this slide that you can call adult protective services about, right? Abuse, sexual abuse, neglect. For older adults, sometimes self-neglect, that's a huge one, right? So people will file for guardianship for their parents because they stopped taking care of themselves. That's such overreach. You don't need to file for guardianship. First call adult protective services and they'll investigate and they'll see if there's any services that the older adult could have that could help them. But just becoming their guardian is not going to help them. It's not going to give them the services they need or the care that they need. Financial exploitation, that's huge, right? But you can call older adult protective services for that, and they can correct the problem. And sometimes the solution is filing for guardianship, but my suggestion is adult protective services decide that. Like you should file a complaint with adult protective services, not file a complaint for guardianship. Okay. So if adult protective services thinks that a guardianship should be filed, let them do it, but let them explore if there's other options to help the person first. Next slide. So this comes up sometimes. Sometimes people think if their loved one with a disability has a legal problem, they will not be able to talk to the police, or they won't be able to talk. And again, I kind of want to reassure people and say guardianship doesn't protect against this kind of thing. If you're someone's guardian with a disability and they get in trouble with the law, they still have to go through the process of that the law requires. You know, they're still going to get arrested. They still might get arraigned. You being their guardian doesn't stop that. But there's a rule of professional conduct for lawyers. It's rule 1.14b, and it says that if a lawyer believes that his client doesn't have capacity, they can take steps to protect that person. So let's say your loved one with a disability gets arrested and you don't think they have capacity.